Hello, this is Jennifer Grady from the Grady Firm, your immigration firm coming from Southern California, and I'm here with Anthony Mans Esquire, our ever helpful immigration attorney. And today we're going to talk about the recent presidential proclamation that limits certain non-immigrant visas for the rest of the year until December 31st, 2020. And this does affect J-1 visas, L-1As, L-1Bs, H-1Bs, and H-2Bs, which are some of the most substantial employment-based visas and a lot of the work that we do. So we have been working with clients over the last week or so that are either in process to file one of those applications or are considering filing one of those applications and answering their questions about how this will affect them. So the main point is that if someone is on that visa already and they're in the United States, they're allowed to remain here and they can reapply for an extension. However, this would affect someone who is outside of the country and planning to enter the US on a visa. So for example, we have an L1A that already we applied for back in March and we're at the RFE stage. We can go ahead and answer that, and if it is approved, that person could not enter until January 1st, 2021, based on the current proclamation. However, if Trump were to remain in power and wants to continue this starting to extend past January 2021, he could do that. Or if there is enough litigation or successful litigation, that could pause this as well. But in the meantime, the way that the law is written is that we would have to be requesting a start date after January 1st, 2021, if indeed we were to proceed with that application. So some workarounds of this are looking into other visas like the O1 visa or the E2 visa, depending on what your case is and what would apply. So Anthony, tell us a little bit about how we could maybe work with someone who had been interested in applying for an L1, but maybe could pivot to look at the E2.
So yeah, the L1 visa and the E2 visa have some similarities in the sense that you're most likely going to be working for a company that is doing business in the United States and doing business in at least one other foreign country. And that is a basic requirement of the E2 visa. So the E2 visa is a treaty trader or treaty investor visa. That means that it's a visa that is given to nationals of countries that have treaties with the United States in terms of trade and other economic benefits. So the requirement for the E2 visa is you either have to be the primary investor or you have to be a key employee that has the same nationality as the primary investor. And the company that is the investment entity has to be doing business in the United States and one other country. So, for instance, if you have a company that was started in France and they establish a branch in the United States, and you were planning on transferring an employee that's in a managerial level or in a specialist level from France to the United States, you obviously cannot do that under the current restrictions. However, if you can show that the company is at least 50% owned by a national of the foreign country, in this case, France, even if that owner is, basically stock ownership, so it doesn't have to be an individual, you can then transfer that employee potentially using the E2 visa instead of the L visa. One of the benefits of that is you just have to show that they're a key employee. Unlike the L visa, you don't have to show that they're going to necessarily be in a high-level managerial position. So it may be a benefit. There are challenges. You do have to demonstrate that the company has the ownership structure, which generally means showing evidence of nationality of the owner, whether it be an individual or a company, showing the investment documentation to show that there's been substantial investment in the United States. That's both initial investment and ongoing investment, and that the employee will be working in a specialized capacity.
And then if we were to start a new business here in the US, which could be somewhat similar to the L1, starting a new new company here, we would have to show that you're investing at least $100,000 more or dollars or more, and that would depend on what type of business it is, how much investment would actually make sense to show that it's not marginal and that it's created more than just for the purpose to live here, but it's an actual business that would be showing a profit. So sometimes that is a deterrent for people looking at the E2, but if the company had already been established and you're from the same country as the owner investor, then that's an option. Or if you were looking to do this yourself, the other thing is that you wouldn't need to have ties to a business already established abroad. You could be starting a new company. So this is an option for people. However, as long as consulates are closed, you wouldn't be able to go ahead and do your interview so that you could get the visa. But when we have clients that we're looking at that maybe have a little bit greater timeline, maybe they didn't want to come here until October, what we could do is apply at that time and we could decide whether we wanted to do the L or if we want to do the E2, assuming that the consulates are open. So kind of a lot of details and nuances that involve the employer, the employee, and different advice that we could give you. So we recommend speaking with counsel on that. Now, what about the O1 visa for people with extraordinary ability, usually in business, science, film, or entertainment?
So that could be another option, especially if you're talking about somebody who was initially planning on coming on an H-1B or an L visa. The business component, the science component may be a potential option. For the O1 visa, you have to show that you are of extraordinary ability, meaning that you have to demonstrate that you are above and beyond your peers in your particular industry. And to do that, you have to provide significant amount of documentation. And USCIS publishes a list of criteria that you have to meet. Normally, you have to either show that you are the recipient of an international award. For instance, if you're talking about film, it would be an Academy Award. In business, it's a little bit more nuanced, but it would have to be something that would be significant to the entire international industry that you're in. The other option is that you have to meet 3 of the listed criteria, and normally that criteria is you have published in a significant national or international publication, you've had a story written about you in a significant national or international publication, you're getting paid significantly more than your peers for your job, you have contributed on a national or international level to your industry, or there's some other categories that are similar, but the bottom line is you have to demonstrate through evidence that you are above and beyond what would be considered the normal employee in your field. But if you do have that evidence and you have a sponsor in the United States that needs to bring you to the United States, then you could acquire the O1 visa.
Great. And so what if someone were looking to apply for an immigrant visa, a green card? How would this affect those people currently?
The current restrictions have effectively stopped the processing of immigrant visas abroad and the entrance of people with immigrant visas that were issued after the proclamation, and that's been extended to December 31st, 2020 as well. It doesn't include people who are spouses of U.S. citizens or children under the age of 21 of U.S. citizens, and there are some exceptions for people that are specifically coming to the United States to perform important tasks involving COVID-19, people that can show that they are of a national interest to the United States. And then from a H-2A farm worker standpoint, people that are coming to the United States to assist the food supply. So there are some very limited waivers for the policy, but generally most people are restricted at this point.
But for clients that are applying for a green card through perm processing, through EB1, EB2, or EB3, we are still moving forward with those applications because they're a multi-step process, and they may have to get a prevailing wage determination, they may have to go through the recruitment process. So by the time they're ready to adjust status, we may already be into 2021. So the hope is that we can get part of this out of the way and then be ready to apply for the green card next year. So we're waiting to see how prevailing wage determinations may be affected by COVID-19 and the higher unemployment rates. We have a few that we're waiting to hear back and see if that's an issue at all or how it's changed. So what we're doing here is trying to keep things on track, keep things moving, talking with clients several times a week, even as the law changes, but trying to help people figure out if there's other ways and workarounds to go ahead about this, and then at worst maybe planning for a later start date. And then something that's happening right now is that USCIS is demanding more money to keep going from Congress, or else they may furlough employees at USCIS. And so we're concerned that that may also suspend premium processing like we saw back in March that was just reinstated in June. So if someone is concerned about filing their application, we are moving others along to get them filed before that potentially might happen in August so that they can get those cases through. So again, it's many nuances, many details, depends on your situation, your timeline, and what's most important to you. And that's something we can help you figure out. You can schedule a consultation with us at gradyfirm.com under the scheduling tab. You can call us at 949-798-6298, or you can email us at info@gradyfirm.com. So feel free to put some comments below about your situation, or share this with anyone else who it might be helpful to. So thank you, Anthony, for your great advice, and we look forward to chatting with you soon.